Why are trustee accountings so important? They can be routine, maybe even boring, or the genesis for shocking discoveries of embezzlement and trustee fraud. Let's take a look at a couple cases straight from the news. California caregiver Donna Crick pleaded guilty to a single charge of theft or embezzlement from a 92-year-old man suffering from dementia. Once Crick had drained the life savings from the victim's bank account, about $172,000, Crick convinced the victim to make Crick the trustee and beneficiary of the victim's living trust, his home, his annuity, and his life insurance, according to a recent release by Kern County District Attorney's Office. Here's another one. Michigan resident Ricky Bradford Wilson, holder of a durable power of attorney for his 90-year-old great aunt, transferred $120,000 in cash from his aunt's bank account into his, signed a quitclaim deed transferring her house to himself, and transferred the title of her classic 1967 Ford Mustang convertible to himself. Attorney General Dana Nessel called this a classic example of financial elder abuse, a trusted relative who took advantage of his aunt. Embezzlement is the fraudulent appropriation of property belonging to someone else by a person to whom it's been entrusted. The theft of property with a value of more than $950 can be prosecuted by law enforcement agencies as a felony. Civil wrongs stemming from the same acts may be litigated in the civil courts. The duty of a trustee to account is fundamental to the fiduciary relationship between the trustee and the trust beneficiaries. The duty to account can be enforced by a beneficiary's petition to the California Superior Court having exclusive jurisdiction of proceedings concerning the internal affairs of trust. Among other requirements is a mandate that there be a schedule of the estimated market value of the assets as of the beginning of the accounting period for all accounts subsequent to the initial account. This requirement is often the Achilles heel, the vulnerable spot for the errant trustee. Trustees who fail to account are vulnerable because in California, the 3-year statute of limitations for a trustee breach of duty does not begin to run until the beneficiary receives an accounting from the trustee that adequately disclose the existence of a claim against the trustee for breach of trust, or facts become known to the beneficiary of the wrongful act. Trustee liability for wrongdoing can thus reach back decades. Trust and estate litigation counsel are often retained to sue trustees who choose to violate the duty to account. We have laws that require trustee accountings to keep trustees from needlessly endangering trust beneficiaries. Trustees, whether banks, trust companies, or individuals, must follow these laws. When a trustee does not provide an accounting, the odds skyrocket that there has been a breach of fiduciary duty. Forensic accountants are called in to determine if this conclusion is right. Violating the rule exposes beneficiaries to partial or complete loss of assets that a deceased parent or relative really wanted them to have. There's a very good reason that California and other states impose a duty on trustees to keep clear and accurate accounts. Courts will resolve all doubts against a trustee who fails to keep proper accounts. Hackard Law represents aggrieved beneficiaries in estate, trust, probate, and elder financial abuse civil matters. We take significant cases where we think that we can make a substantial difference, and there is a wrongdoer who can be made financially accountable for their wrongdoing or their breach of duty. We represent foreign, out-of-state, and California clients in California trust and estate litigation. We focus our geographic reach to California's largest urban areas, including Los Angeles, Orange, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento counties. If you'd like to speak with us about your case, call us at 916-313-3030. We'll be happy to listen to your story. Thank you.